I show up to Washington, D.C. and just start knocking doors, going down. People are floored, like, what the heck is going on? People are taking pictures with me. We're going, and next thing I know, I got 15 missed calls from the Pentagon saying, Specialist DeRito or Sergeant DeRito, are you, or I was a specialist at the time because I was waiting to get promoted to sergeant. They're like, are you walking around the halls of Congress? Like, what? I'm like, yes, I am. They're like, who authorized you to? I'm like, well, I'm not here on a paid status. I'm on Title 32. I'm just here on my own volition because you guys won't fix my record. So I guess I have to go do it myself and force my congressional members to force this issue, right? So then we start drafting something called the DeRito Act, right? Because we realize they're not going to fix my case administratively. I've done all the right things. I've gone through the court systems. I've gone to the president. I've gone to the SecAF. I've gone to the Secretary of Defense. What other recourse do I have? So if the judicial branch isn't going to do anything and the executive branch isn't going to do anything, then I have to go legislatively. So we formed this, we call it the Military Mental Health Protection and Justice Act, which we just call the DeRito Act because it's easier to remember. But there's nothing in the UCMJ that prevents commanders from using command-directed evaluations or CDEs from falsifying your mental health records in retaliation for reporting sexual assault, harassment, or misconduct.
That's just so crazy to me that you even have to have a law to say that you can't do this. It's like saying that you have to have a law in the book to say that you can't steal. You know?
Correct. But this is how the commanders circumvent the Vanessa Guillen Act, the Brandon Concerta Act, and the Sergeant First Class Stay School Act, right? Is that, Vanessa Guillen, it takes sexual assault investigations away from the commander and puts them into another DOD entity. Great. Right. The Sergeant First Class Stay School Act takes medical malpractice, and you can't sue them in the civilian courts, but you can sue them through another DOD JAG office, like the Defense JAG, whatever office in the Pentagon.
You can go through the service branch departments at the Pentagon and basically have them like investigate themselves.
Which to this day they've never adjudicated a single case since 2017 with that act. And then the Brandon Concerta Act allows service members without retaliation to seek mental health services, but it doesn't say that they can't put you on restricted status, can't take away your job, can't take away your flight status, everything else. Right? So the DeRito Act closes that loophole finally.
On all three of those things?
On all of them. Because it says if you do and if you change those records, now we can charge commanders under...
Or retaliate, or take away your flight pay, or do any of these other things.
That loophole that's closed states in the Act, which is what I get constantly fought on, is that we can charge you under HIPAA, which are already existing federal laws that civilians are entitled to under their constitutional rights, that if your doctor cuts off the wrong leg, you can sue them, right? In the Army, you can't do that. So we wanted to say, if there's any service members specifically to command-directed evaluations, because you got to go small, you can't just act big, right? You're not changing Ferris Doctrine overnight. It's never happened, right? But if I can do CDE...
Just on the CDE.
Just on the CDE.
Because you had a CDE in your case.
Unbeknownst to my knowledge, yes.
Yes.
I never knew about this.
And to this day, you don't have any documentation of that CDE, do you? You don't
I have nothing.
You don't have anything, any administrative document that says that your commander... That lieutenant colonel.
No, you see the medical records are on my website.
Ordered a CDE, but you just know by those notes from
Nicole Henley Price.
I'm sorry, Nicole Henley
Price.
Okay. You know from those records that your commander ordered her to conduct a CDE.
Correct.
Or referred you to her.
Well, and on top of that, what came out during our investigation was, remember that cadet that was in that unprofessional relationship with, that reported the Chief Master Sergeant? So she made it through all 5 years of the academy because she was at the prep school and then all 4 years at the academy. And then she got charged as a cadet, which we found out through our work in 2015. She was having sex with this married guy with 3 kids the entire time she was a cadet and while she was a prep school cadet, and was charged under court-martial with this guy because they got caught at a hotel. And then she was going to marry this guy when she graduated as a second lieutenant because he was retiring as an E8 or whatever, E7 or whatever it was. And then he was divorcing his wife. They got an apartment in Colorado Springs. I'm like, so wait a minute. And then if you look at the time frame on there, it says September 2009. So that was the exact time frame that I reported and the exact time they accused me of fraternization. So the reason why that girl and all her friends accused me of fraternization because they were covering up for her unprofessional relationship with a senior enlisted person of the United States Air Force Academy, which is McMahel versus USA. You could look it up on the internet. Her name is abbreviated as HL, right? It lays out the whole thing. And then she walked away. Today, she's a major in the United States Air Force. That guy got a dishonorable discharge as an E2. So we submitted that as new evidence in the appeal, saying like, this is all monkeyed up. Like,